case briefs, and so much more. LSData's got what you're looking for.
The Power Engineering Company, PC, Redoubt, Limited, and co-owner Richard J. Lilienthal found themselves at the center of a legal storm over Colorado's environmental regulations. In this high-stakes dispute, the United States government sought to enforce financial assurances in a hazardous waste cleanup originally initiated by PEC's lucrative metal refining business. The players were contending not only over who would foot the bill for contamination, but also who held the authority to enforce the state regulations in the first place. At the heart of the lawsuit was the Resource Conservation and Recovery Act of 1976, RCRA, adopted by Colorado's Department of Public Health and Environment. This case hinged on the financial assurance provisions under the RCRA's Subtitle C, which dictated the handling protocols for hazardous waste to protect human health and the environment. The question posed was whether the EPA could enforce state regulations independently or if they had to compel compliance with the whole permitting scheme first. In the initial court proceedings, the defendants disputed the applicability of the RCRA and state regulations, calling into question the government's likelihood of success. However, the district court rejected these arguments and granted an injunction requiring them to provide a hefty $3,500,000 for remediation efforts. Not one to back down, PEC countered with claims that they were not a treatment, storage, and disposal (TSD) facility, and as such, should not be required to comply with TSD regulations if they resolved to clean up the hazardous waste pre-closure. Predictably, the court shook its head at such reasoning. Upon appeal, the attention was undividedly cast on PEC, particularly their illicit disposal of hazardous waste. Defendants were found guilty of polluting the facility soil with chromium and maintaining hazardous waste piles, placing them squarely under Colorado's TSD regulations. The High Court resoundingly affirmed the verdict of the lower court, maintaining that the EPA had the right to enforce state regulations and confirming the necessity of compliance for closure and post-closure of the hazardous waste facility. The defendants' protests over how the financial assurance estimate was derived were dismissed as the court upheld the injunction for $3,500,000. In the final hammerstroke, the court affirmed that financial assurance plays a crucial role in the remediation of environment contamination, rejecting PEC's attempt to wriggle out of its responsibility.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climate.